Welcome back to the channel. This story is somewhat unfortunate because this chap seems to have been given a fine as it's described in the article, which I actually believe is a parking charge notice as against a fine, which I've discussed in lots of other videos, whilst he was only getting out of his car to look at the terms and conditions of parking, decided not to park and drove away. Nonetheless, it appears that he's been given a parking charge notice and has been fighting this ever since. He said he would rather go to prison than to pay for these charges. He said in the article that he spent £2,000 in fees, that's presumably legal fees, and 18 months fighting this private parking fine, as it's discussed in the article. As I said, it's not a fine, but it still has the effect of feeling like a fine because you're being charged a sum of money for allegedly breaching the parking restrictions. But the point of this whole story is, if you park your car and walk away and leave it, that is what the courts have determined to be parking your car. If, on the other hand, you take a reasonable opportunity to read the parking signs, the terms and conditions that you will be held to if you do park your car, and you decide that you don't agree with them, and therefore you drive away because you don't agree with them, I cannot see how any company can try to uphold a breach of contract because you haven't accepted that contract. Now, there's been much discussion, debate, and even on occasion disagreement about the fact that you do enter a contract when you park your car on a private car park, even though there's nobody else there and the payment system is automated. This is an automated payment system and transaction with the parking company. Now, if you do park your car, as the courts have said, when you walk away and leave your car there, that's what the courts have determined to be parking your car to be, then of course you are entering that contract. But if you don't accept the terms and conditions of parking and drive away, then I agree with this driver that they shouldn't have been issuing a parking charge notice. That should have been the end of the matter, and they should have acceded to his request on appeal, because that would have been the reasonable thing to do. However, according to the article, none of that was successful, and there's a bunch of letters, as you can see here. The problem, however, came when he received this document here, which is shown in the photograph, which appears to me to be judgment for the claimant in default. Now, what this means is when you're served with a claim and you don't respond to the claim, either with an acknowledgement of service or with a defence within the requisite timeframes, then the claimant can obtain judgment in default, regardless of whether the claim had any merit or not, because the court is not going to look into the case to see whether there's any underlying merit automatically, and usually will just grant judgment in default of responding to the claim. The problem we have here is that this chap says that he did not receive any letter from the court, and therefore I presume that is the basis on which he's sought legal advice to have this judgment in default set aside. Now, pausing for a moment for a bit of a warning, if you do receive something in the post from the court, you absolutely must comply and respond within the timeframes provided. Those timeframes are 14 days initially to either file an acknowledgement of service or to file your full defence within that 14 days. If you file your acknowledgement of service, you then get an additional 14 days within which to file your defence. If you want to learn much more about all of these rules, I go over these rules on my website, BlackBeltBarrister.com. The Civil Procedure Rules course is under construction. It's currently available for free as part of the subscription, and I'm building this out, and hopefully this week, next week, I'm going to finish that course so you can all read more about the rules. This is particularly useful to law students and bar students, so I encourage you to check that out, while the price is currently set to reflect the fact this course is not yet finished. Moving on, if you want to set aside this judgment in default, there are two provisions within the rules that allow you to do this. Now, without getting bogged down into those rules, the broad position is this. There is one set of circumstances where the court must set aside this judgment. Set aside the judgment means it's no longer an enforceable judgment and the court is going to hear the claim substantively in court. And so you can ask the court to set aside the judgment in certain situations. The court must set aside the judgment if, for example, the time frame for filing the acknowledgement of service or defence has not yet elapsed. In that situation, if somehow they've obtained judgment in default, it must be set aside because those timeframes didn't elapse. Certain situations where the court may set aside the judgment, that means the court makes a judgment as to whether or not they set aside the judgment on a given set of circumstances, and one of those might be if you can show that you didn't receive the court documents in the first place, and it might be that you didn't receive the full response pack. For example, if you only receive the claim form, but you don't receive the response pack, which is the bit that you fill in to respond to the claim. If you didn't receive all of that, or it just didn't come to your address at all, because this is much more common than you might realize, things going to the wrong address, and therefore you don't receive it, therefore they can obtain judgment in default. The problem that this spirals is that once they have judgment in default, and until it's set aside, they can use enforcement methods, so third-party debt orders, charging orders, writs and warrants of control against you because they have a judgment in hand. They are the judgment creditor, you are the judgment debtor, until it's set aside. Now, some people got wise to this. This is absolutely not something you should think about doing because it's wrong. It would be perverting the course of justice to do what I'm about to say. But some people do put the wrong address in deliberately, knowing that it's not going to arrive at the person's address. Therefore, they don't receive it, therefore they don't respond to it, therefore they can obtain judgment in default. As I said, that is wrong. You cannot do it. You must not do it. It's perverting the course of justice. And even if you do that and you think you're clever because you've got this judgment in hand, then you go after them for the judgment, they will be to a lawyer and straight to court to have this judgment set aside because it was served at the wrong address. The address was wrong. I can't remember how many times I've been to court for clients that have been served with a judgment in default and they've never seen the papers because the address was wrong. Sometimes the same client has been served 2 or 3 judgments in default, none of which they've seen the papers for. And when we do have sight of the underlying papers, the addresses are either completely wrong, fictitious, transposed, mixed up, and ultimately they just never made their way to my client. So as I said, I've lost track of how many times I've been to court. It's very simple. I'm in and out of court in probably about 5 minutes because I've already served my skeleton argument to the judge to say, this is why we should set this aside, because the court has the power to do so on the basis that the client did not receive these documents in the first place. Therefore, the client could not respond to the claim, therefore the client should have an opportunity to respond to that claim. And therefore, in all but the most exceptional cases, the judgment is set aside and we wind back to the beginning. Moreover, if such a hearing is contested by the other side, given reasonable notice of the reasons we want to set it aside, we might end up with costs as well, which means regardless of it being a small claim or whatever it might be, the other side might have to pay my client's costs for everything they've paid me to get this judgment set aside. Because if they instruct me and I write to the other side and say, we should agree to set this aside because these are the reasons, they should really accede to that request because it's a reasonable request and the judge is most likely going to grant the application. So as I say, a few lessons to learn out of this story. If you are reading the terms and conditions of the sign and you don't park and drive away and then they slap you with a parking charge notice, I think you should fight it because you didn't park your car. Obviously, you might need to take formal legal advice rather than rely on this video because this isn't formal legal advice. But then if you do end up getting court papers for recovery of the money, don't ignore it because they will get judgment in default. And if you get judgment in default, don't ignore that either because they can go after you with enforcement options such as third-party debt orders, attachment to earnings, and all sorts of other things. So if you didn't receive the papers, you can apply to set it aside if there are circumstances that might allow you to do so, all of which you may need formal legal advice for. But in the meantime, as I say, check out my course in that website linked below. Hopefully that will help you to understand some of the rules better, and I'm rolling out that course. I'm on a mission now to finish that rules course over on that website. So I hope you enjoy that. I hope you find it useful. Please smash the like button and subscribe, and I'll see you next time.